Sure. Thanks for having me. My name is Lucy Rika. I'm the Director of Policy and Programs at the Deborah L. Rhodey Stanford Center on the Legal Profession. And I've been associated with the center since 2013 in a variety of capacities. I also spend almost all of my time thinking about and working on regulatory reform related to the legal profession and the practice of law. And most specifically, I've been involved since 2018, 2019 with the reforms that have occurred in the state of Utah. And I was the first executive director of the new Office of Legal Services Innovation, and now remain on the executive committee and on the board of that office, which is overseeing the new regulatory sandbox, which we're going to talk a little bit about today.
Excellent. Thank you, Lucy. And speaking of Utah, let's turn it over to Deno.
Hi, I'm Deno Himonas. I used to be on the Utah Supreme Court until March of this year. I served as a trial judge for 11 years and a Supreme Court justice for 7. And in my tenure on the court, I led the charge in Utah to open up the practice and really completely redo the regulatory paradigm that is employed to govern the practice of law. And by that, I'm referring to the sandbox, and more about that from all of us in a little bit. Thank you.
Great, thanks, Deno. And finishing up the introductions with Crispin, who will also lead off our presentations.
Thanks, Chris. I'm Crispin Passmore, all the way from the UK, and delighted to be invited to come and talk to you today. I've worked in the legal industry for far too many years, probably 35 years, something like that. I'm not a lawyer, never been a lawyer, never wanted to be a lawyer, but love lawyers and love the legal industry and the things that they can achieve for communities and people and businesses. I worked in a range of roles from a non-profit through to legal aid. Spent 10 years as a regulator trying to liberalise the UK or England and Wales legal system. And for the last 3 or 4 years, I've worked as a consultant with legal businesses, law firms, investors, big and small, global and local, on how to deliver change, disruption, and innovation in the legal market. Thank you. So shall I kick straight off, Chris, and do some introductory remarks? I think
Absolutely.
all three of us are going to talk, and then we'll come back into some discussion. So I'll try and keep my comments brief. In some ways, I'm not going to make the case for regulatory reform. I'm going to make it in a round the side sort of case. In lots of ways, whether or not regulators reform and whether bars and state bars liberalise and open up is not really that relevant, because I want to try and explain that there's ways around all of this, and that innovators will find ways to innovate even if state bars don't change. But why is there a case for it at all? Why is there a case for change in the way legal services are delivered? And the answer to that is pretty simple. It's because around the world, and particularly in the US, ordinary people don't get access to the legal services that they need to tackle the issues, risks, problems, disputes, challenges that they face in their lives. And research after research shows that the pattern of legal need and the weak supply to meet that legal need is pretty similar in developed countries around the world. But the gap, the access to justice gap, is pretty significant. And it's even worse in the US than it is in most developed nations. And lots of that debate about access to justice is about disadvantaged Americans, disadvantaged citizens. But actually, that's only part of the issue here. Middle class Americans struggle to pay for the legal services they need. The best advice most lawyers give is don't go to a lawyer, because most lawyers can afford their own services. So what chance have ordinary folk got? There's a real crisis for ordinary people to get the legal services they need. And that applies to small businesses as well. If you're running a small builder, if you're running a shop, if you're employing a few people, if you're taking on your first property lease, online sales, international trade, all of these things are legal issues that lawyers can help with. But most small business owners find that lawyers, attorneys are not a great way to handle their problems. They don't manage the relationships well. The costs are unpredictable and difficult to control. And that research, again, has been replicated around the world and shows that access gap really cuts across to small business as well. But actually, it also applies to corporations. Why should a large corporation, however big and well off it is, just have to overpay for its legal services to suit lawyers' preferred business models? It just doesn't make any case. It feels, therefore, like law becomes a tax on the efficient operation of business rather than a facilitator of business decisions. So across all of those different markets, there's a case for change, and over-regulation is stopping that change and it's stopping innovation. But perhaps more importantly, it's not stopping it completely. It's simply moving it into a separate place. It's moving it away from law firm, lawyer partnership, traditional practice of law, to a place where most lawyers don't have to think about it and don't have to confront the competitive pressures that are happening in the market. And if they don't have to think about it and confront it, then as long as there's some protection in the way that the market's structured, they can continue to make profits and carry on. Regulators don't get to decide if innovation happens. We could spend the next hour debating whether or not regulatory reform should happen, whether innovation should happen, but it's not really up to us because innovators are out there and doing it already. LegalZoom, Axiom, Rocket Lawyer, global businesses, the big four accountancy firms, Lawyer on Demand, Elevate, startups like Hello Divorce and Visa Place. You could come up with list after list of small and large businesses that are already innovating and finding ways to solve what you might call legal problems, risk management problems, disputes problems, intellectual property problems. All of those different issues are being solved by people that are businesses that are not breaching the unauthorized practice of law. They're not breaching fee sharing restrictions, but they are meeting customers' needs. And they're doing that by finding ways around regulation. So it's not for regulators to decide whether it's happened. They're 20 years too late to that party. Axiom's 21 years old. The big four employ thousands of lawyers in the US. They're not there to make the tea. They're delivering things that look remarkably like legal services, even if they don't fall within the definitions of legal services. And private equity is investing in the legal market by the multi-million-dollar. And it's not breaching UPL, it's not breaching fee sharing, but it's finding ways and structures of bringing their expertise and their capital to invest in technology, to invest in growth across the US, and then helping businesses go global. And it's doing it quietly, under the radar, and innovating and driving change. So it's a global market as well. We can take pretty much any lawyer working in the US, any law firm, any legal business working in the US. We can take pretty much any client that wants legal services. And with a little bit of imagination, we can route their needs and their supply of services through London and completely bypass regulatory restrictions in the US. So it's not about whether you want change to happen. The real question for lawyers and regulators is not, do you want change to happen, but do you want to regulate it, and do you want law firms to be allowed to compete? And if you don't, then over the next 20 years, lawyers will face the same fate as every guild throughout history, which is as they build bigger walls around their market to protect them, innovators build a motorway to the future, and the guild gradually disappears. Increasingly, me and my clients, despite me being a regulator by background, we don't care about UPL and regulatory restrictions. We think we can make it irrelevant, and our businesses are getting clients that are helping them grow rapidly, satisfied customers that are choosing them over traditional law firms and being successful. So we think we can do this, do change without reform. But if you care about traditional law firms and the opportunities for lawyers to practice, then you'll get behind regulatory reform because you want lawyers to have the opportunities to compete in this market. And that's really what I want to push. What might a prescription look like? Very quickly, you've got to let non-lawyers own and invest in law firms. You've got to let lawyers partner with other professionals and business people without structural restrictions. You've got to rethink UPL, restrict the monopoly on the practice of law to where it's really needed, such as litigation and advocacy. And we've got to widen what we mean by attorney or lawyer to allow more paraprofessionals to litigate and advocate in court in particular areas. And I would say finally, most of all, we need to make state bars, regulators independent of the people they regulate. Because if we do that and we bring in people with regulatory expertise, change will happen very quickly. Thank you very much.
Excellent. Thank you, Crispin. And turning it over now to Lucy for her thoughts.
Thank you. I'm going to share some slides because Crispin laid out a great sort of call, and I'm going to talk a little bit about what's going on currently. So forgive me for 1 second. Does that work for everybody? Let's see if I can. Ooh, hold on 1 second. Nope. There we go. Okay. Try this again. Okay. Great. So as Crispin said, the challenge that we're dealing with, that he is working very hard with his clients to figure out sort of ways around, is the restrictions that we've built up around the legal profession and the practice of law. And, I think, many of us in hearing Crispin's presentation would say, no, we don't want these services to exist, building up outside of the regulatory sphere. And we do want lawyers and law firms to be able to participate and compete on a level playing field. And so, so that's really the challenge. And I think he laid it out really well. The two main areas that are of restriction that are really impacting our market and our business and people's experience with that are the restriction on through 5.4 on sharing revenue and ownership with non-lawyers, and the unauthorized practice of law rules and doctrine, which limit all legal practice activities only to lawyers. So the challenge for us are these questions. How can we bring the cost of legal services down? How can we support scaling of legal services to many, many consumers? And really, like from a regulatory standpoint, how do we regulate to ensure that we're doing this, that we're supporting this innovation, that we're supporting this scaling, and that we're supporting these new models and these innovators that want to develop new services, but also protecting consumers, because that's what ultimately we really care about. So we've got a couple of states that are moving forward and really have moved forward in the past 2 to 3 years in really kind of transforming their thinking about how to regulate the practice of law and legal services. And first up is Arizona, which I believe it was 2021, I think was when it went into effect, that completely eliminated Rule 5.4, which is, as we know, the rule that prevents lawyers from sharing revenue with non-lawyers. And now allows those businesses to exist, legal practice entities that are owned and managed by non-lawyers, and it regulates those entities as alternative business structures. This is a form of regulation. This is a structure that is very close to what the UK has done, that they enacted in 2007 and implemented in 2012. And the second major piece of Arizona's reform is paraprofessional licensing. So they've now got a robust kind of structure around paraprofessional licensing. There's a little more detail on each of these. At my last check, there were 22 alternative business structures authorized. Among those, that's a small number, but among those are LegalZoom, Elevate, and most recently, I think, Crispin, I'm right about this, Axiom. So those are big entities that are, have a big impact for consumers as well as corporate clients. And this is just a little bit about the regulation. This is all run through the Supreme Court in Arizona directly, the regulatory structure. Arizona ABSs are required to comply with a code of conduct and have a compliance lawyer, etc. Licensed paraprofessionals, at my last check, there were 18. It's actually a really interesting structure that they've built out. It's either education-based or experiential qualification. They can practice across a pretty wide berth of legal service areas, and they have a pretty broad scope of practice, including in-court representation. So really interesting structure in Arizona. And it'll be really interesting to see how that continues to develop. Utah, which Deno and I are heavily involved in and have been, obviously, for some time, took a different approach. Ultimately, I think we're going to end up between Utah and Arizona somewhere that there's a more coherence and similarity between the two structures, but as of now, they're relatively different. Utah has done a lot of innovation in thinking around how to reform legal practice and the regulation of legal practice to increase access to justice, starting with their ODR program, which basically is an opt-out system for all small claims. I think it's under 15,000, Deno, if that's, I'm not sure. Yeah. So folks are automatically routed into ODR for all of small claims unless they opt out of that system. So that's a big,
11, Lucy, sorry.
Oh, okay.
But they're moving.
Okay. So that's a big change as well. It affects a big sector of folks that are dealing with small claims. They're also have implemented a paraprofessional licensing scheme as well. But the area that I think has gotten the most coverage and that we're going to talk a little bit about in more detail today is this regulatory sandbox, which is Utah's approach to allowing for not only non-lawyer ownership and investment and revenue sharing between lawyers and non-lawyers, but also innovation around unauthorized practice of law through entity regulation of legal service entities rather than people. So this is what exists in Utah now. We have sort of a dual system of regulation. The Utah State Bar continues to do what it has always done, regulate lawyers through the rules of professional conduct. And the Office of Legal Services Innovation is an office within the Supreme Court of Utah that is administering the sandbox. The court makes every ultimate decision about who gets authorized and the scope of their authorization, but the Office of Legal Services Innovation is actually doing the kind of day-to-day administration, recommending applicants to the court, and has set up this risk-based regulatory framework to assess applicants at the outset, what they're proposing to do, and then what ongoing regulatory requirements they have. All non-traditional legal service entities, any entity that is partially owned by a non-lawyer, where you've got non-lawyer investment, where you have revenue sharing going on, or where there's non-lawyers offering legal practice services, has to be run through the sandbox and regulated through this Office of Legal Services Innovation. This is what the sandbox looks like. It's, as I said, all of these non-traditional entities, anybody who's got an idea that sort of pushes up against the traditional barriers around the profession, specifically 5.4 and unauthorized practice of law, but anything else is also on the table. If somebody has a kind of interesting payment platform that they want to try out that might violate Rule 1.15, they could come into the sandbox if the court was willing to authorize them. So they can apply to enter. They are recommended to the court for authorization. The court does or does not. And then depending on what their proposed model is, they have certain data reporting requirements that they're required to submit that are really about at the level of the services that they're offering. So what kind of legal services are you offering? Who's providing the service? How long did it take? What did the consumer pay? This sort of data so that we have a good sense of what's going on the ground. And they also, certain entities have to submit to audits of their services, particularly those that are using software or non-lawyers to provide legal services. And then once they've sort of satisfied minimum requirements, ultimately the vision is that they exit and become authorized as licensed legal services entities. We are still, I think, a ways from that, but we are gathering a lot of information about what these new services are doing, which is particularly relevant, less so for ABSs. I mean, I think in ABSs, in these where there's just ownership or management innovation, lawyers are still doing all of the work. They're working as traditional lawyers. They're already regulated by the bar. So there's less concern around that. What we're really interested in understanding is how softwares could be practicing law, how non-lawyers could be offering legal practice services, what the experience is of consumers there, what are the risks. We don't know very much about what this looks like because it's really never been permitted before. And so we want to learn and we want to create a regulatory system that supports and permits services while at the same time making sure that consumers are protected. So that's the vision. We've this is the current stats of the sandbox. We've had 65 entities apply, 39 are authorized. And because we're collecting this data, we know a fair amount about what's going on. We've had over 20,000 services provided to over 12,000 distinct consumers. And 9% of those, which is small, but it's growing, it's up 1% since the last time I did this presentation, are delivered by a non-lawyer, which is exciting. I mean, we really see such huge opportunities for scale and for discrete, affordable legal services for regular consumers when you have non-lawyers and when you have technology providing services. So we're excited to see that number grow. This is sort of a breakdown of the areas of law that we're seeing in the sandbox. And I would be willing to bet some money that maybe accepting the veterans, because that's a unique situation because of one provider that we have. I bet that in the ABS context, it's relatively similar, this breakdown. We're also seeing that a diversity of geographic service provision in the state of Utah. And this is exciting to see. Already, this has only been going for less than 2 years. Already we are seeing services touch everywhere that lawyers are touching. And even more so, we're seeing services being provided in quote unquote legal deserts in Utah, where there's only one lawyer basically for the whole, I forget exactly what the definition is, but it's essentially one lawyer for, I think, about 12,000 people. And so we're seeing that these services are touching these legal deserts. We also know a fair amount about, what consumers are, if consumers are experiencing negative impacts from these services, and we're seeing very, very little there. We look to see whether consumers are experiencing these kinds of harms, which we've identified as uniquely, the kinds of harms that we're concerned about from legal services: bad quality service, a failure to identify a right, or to identify an important fact related to a right. And then upselling, purchasing a service that's not necessary. And we're really not seeing very much of this happening at all. Over the entire 2 years that these entities have been going, we've seen only 5 of these complaints, and all are remedied satisfactorily. All have been remedied satisfactorily by the entity at hand, which means they've, provided remediation, they've refunded service money, et cetera. So we're really happy to see this, and more so, we're happy to see this kind of data coming in, because so little is known about how consumers experience legal services, and that's really one of the larger goals of this project, is to build an empirically driven regulatory system that grows our knowledge of how consumers experience services and where consumers really experience harm, so that we can have informed decision making going forward. These are the states that are considering implementing some form of legal entity regulation going forward: Michigan, California, Washington, and North Carolina. And, we're hopeful that no matter what they choose something, whether it's paraprofessional licensing, whether it's ABS licensing, whether it's a sandbox. But we hope that they will be as broad in their vision as they can be, because we know, as Crispin defined or set out for us, there's a broad swath of need, and we really need really bold decision making by the leaders in these states as they move forward. And so we're excited to see what happens in these states. I'm on the working group for California, and it's a slog, but we are working hard to kind of see if we can implement a version of this in California. They also have a paraprofessional licensing working group. That's it. I'm happy to answer any questions, and I will stop sharing, and feel free to reach out to me directly.
Great, thank you, Lucy. That was impressive, especially the data you're gathering in Utah. It's great to see specific results and that you're tracking those. Our final presenter will be Deno Himonas, and we will get to the questions that you're posting in the chat, and thank you for posting those. But first, we're going to let Deno have a say, and then we'll go to the Q&A.
So thank you, and thank you for the opportunity to speak. And I should say that after leaving the court, I joined Chris at Wilson, Sonsini, Goodrich, and Rosati, and have been having the time of my life back in the practice of law. Hard to believe, but it's true. What I want to do is talk about 3 things. One, I want to take on a couple of the arguments that opponents have uttered. And you've heard reference to these, but really kind of lay the lie to the arguments. Two, I want to talk about some of the advantages really quickly when we're talking about legal technology of using the sandbox as a regulatory model. And three, I want to touch on, and most importantly, the recent Upsalt decision that I'm betting most of you are familiar with. So the arguments that we hear is, well, you can't allow for outside ownership because, well, every lawyer's ethics are for sale. And if you allow for outside ownership, the ethics violations are just going to go through the roof. One, Crispin will tell you from measuring in the UK, not the case. Just statistically, that's not happened. Two, as you can see from the slides that Lucy has put up, and hopefully Lucy can either confirm or deny. I think we're close, I'm hoping, to publishing a report indicating that based on now a sufficient data set where data scientists can say with a high degree of confidence in the US under a similar structure in the sandbox, just no higher risk of ethical violations than if you had a lawyer. And frankly, I think it's actually lower because if you think about it, we're encouraging reporting through the sandbox, and that's just not the case with law firms. So the data just simply doesn't support the notion. And again, and just anecdotally, right? I mean, in-house legal departments are effectively, right, captive to kind of an outside owner. And we still don't see this kind of uptick in legal misbehavior. So not true. The second is that the advice these folks would receive is just not as good if it's coming from a computer or if it's coming from a paraprofessional. Again, the data simply doesn't support this notion. There's not a lot of data when we're talking about non-lawyers versus lawyers, but there is a study out of the UK in the late 90s, early 2000s that looked at error rates between solicitors and non-solicitors in key areas like healthcare, landlord-tenant, debt collection, and the error rate was similar. It was quite high, 25%. But what was shocking is that the non-lawyers were 600% more likely to be ranked excellent than the lawyers and the solicitor. And that makes perfect sense. Look, I did a divorce case about 13 or 14 years into my practice, right? As a lawyer, I represented an old college friend in a divorce case. I will never open that file because I would have to turn myself into the bar for the numerous ways I committed malpractice, no doubt in that matter. Can you imagine if that individual is better off being represented by me versus a paralegal who's been doing this for 20 years and done nothing else, right? And it's just, I mean, again, I think you can see anecdotally that's not the case. So this two-tiered system of justice complaint doesn't work. The other thing is people forget you have to benchmark this stuff. And we're benchmarking it against zero advice, right? So it's not like lawyer versus, paralegal, it's lawyer versus nothing. Which is what the vast majority of people in the arenas we're talking about, we're really talking about what they receive. Second point, I think there is good reason and information to suggest that employing a sandbox as a regulatory model is good for legal technology and increases funding. I think I've seen some studies that talk about sandboxes and AI, just generally speaking, that about a 15% increase in capitalization as a result of using that model. And would note that the EU in April of 2021 advised its member states that if AI is the driving force in whatever the subject matter, to implement a sandbox-like regulatory structure. I think that's really important. I also think it puts the light of the notion that the sandbox is deregulation. That drives me crazy. It's re-regulation. And I guarantee you that the entities that are participating in the sandbox and have monthly reporting obligations, right, and are going through this, if you ask them if they think they've been deregulated, is because of it's just paradigmatically a different approach to how we govern the practice of law. It's data-driven versus prescriptive. It's not let's guess what's good and bad and put a bunch of laws in place, some of which are highly anti-competitive. It's let's make a decision in what's in the consumer's benefit based on actual data by beta testing this, in a controlled environment. I'm just, yeah. You can tell I get a little passionate about this. All right. Well, we're making some real progress. And why do I say that? Upsolve, right? You all may remember that in January of this year, a dear friend of Lucy's and Crispin's and mine, Rohan Pavlari, decided to sue the state of New York. So Rohan is not a lawyer, but Rohan has put together this service where you'll train non-lawyers to provide legal advice for free to people suffering legal debt problems. A problem with that is, of course, that's clearly violative of the unauthorized practice of law and could get you a civil fine, a misdemeanor, or a felony, depending on the jurisdiction that you're in. So he had a wonderful idea and brought a First Amendment challenge, 2 claims. So one an associational claim and one a speech claim. In May 24th, I believe, a couple of weeks ago, Federal District Court enjoined the enforcement of the unauthorized practice of law regulations against the individuals. It was an as-applied challenge against the individuals that Rohan was representing. So first, the court dealt with the associational challenge and didn't dismiss it, but refused to grant the injunction on that basis. But the really interesting part of it is the court went on to make clear that giving legal advice, so we're not talking about conduct, we're talking purely about speech, and the court was very clear about that. We're not talking about entering an appearance, we're not talking about filing with the court, we're talking about speech, and we're talking about free speech, so not commercial speech, right, is protected. And that because it is speech and not commercial speech, then where there's no rational basis review that applies in this particular case, right? The law has to be narrowly tailored. And if you read the opinion, I mean, the court appropriately so was completely dismissive of the notion that bare unauthorized practice of law statutes and say it's just against the law to practice law is narrowly tailored. I mean, on its face, it is as far from narrowly tailored as humanly possible. So these individuals, right? So I think what we have now are trained individuals who aren't charging, who are providing advice in this space. It wouldn't be limited to this space, obviously, First Amendment violations, and they're going to trump. Interestingly, and I'd be interested in Lucy's and Crispin's thinking about this, I think that Utah's in a bit of a different space because we don't, while there's a general UPL restriction, there is an avenue. So it's not, I mean, when you consider the entire regulatory framework, individuals like these folks can get licensed quite easily. And a perfect example, and what I love to use is we started with Timpanogos Legal Center. It's a women's domestic violence shelter where trained domestic violence advocates get to give legal advice to victims of domestic violence and helping them fill out their forms and what have you. So again, they're not representing them in court. They're not filing. But they get to provide that advice, and we have already provided that mechanism. So I don't know if this might serve as as a way to suggest to states that they ought move in this direction. But I can't overstate the importance of the Upsolve decision. I don't know if it's going to be appealed or if it has been. But if it stands as is, it is my prediction that it is going to upturn the way the law is regulated. Thank you.
Great, thank you, Deno. But actually, Lucy and Crispin, any thoughts on Deno's question and sort of the potential impact of Upsolve?
I wouldn't claim any expertise on Upsolve, but just to pick up something Deno said at the beginning about, this isn't deregulation. I think he's right. I don't think anyone in the US is talking about deregulation. But just to make the case for deregulation, you can look into the UK, and most legal services are not regulated. It's not that they've re-regulated them to allow paraprofessionals or certain types of business people to deliver legal services in a regulated environment, the vast majority of legal services have always been allowed to be done by all of the rest of the population other than lawyers. It's a really small list of things that are reserved to lawyers in England and Wales, and we don't have bigger ethical problems than any other country. We reserve practice of law in litigation and certain courts, only higher courts really, but we allow everybody else to go and deliver legal services. And accordingly, even pre-Legal Services Act, we had a dynamic and thriving legal market with all sorts of innovation way beyond law firms for more than 100 years. So luckily America can look around the world and see all the natural experiments, and they work.
Yeah, I think that's a really interesting point, because what I actually see Upsolve as is, I mean, I think it's fantastic. I think it's long overdue. It's obviously very narrowly, I mean, they were brilliant in how they scoped that case, but it's very narrow, right? It's free legal advice, simple advice, filling out a state approved form to respond to a consumer debt action. So super narrowly scoped. But ultimately, if, as Deno said, if that Upsolve injunction stands and if it is carried to other states, that is deregulation. Like, that will then say that for this type of free legal advice, limited, simple, perhaps connected to state forms, that will not be regulated as the practice of law. And so that will bring us closer to the UK in a small way, maybe, but it will bring us closer to the UK. There's so many different things going on, and I think all of them, yes, and for all of it, right? I think we need so much change, and we need so much more innovation and access, that all of these pieces are super important. And so I'm pleased to see all of them happening now.
Excellent, thank you, Lucy. And Crispin, why don't we turn to you for the first attendee question. Susan Hackett asked, what can we learn from the SRA experience in the UK? Basically, what has succeeded in their efforts, what might we avoid or learn from? And I'd love to use facilitator's privilege and to sort of extend the question, because I had the same one. And you talked early on about increasing access to justice, both for folks who might not be able to afford it, middle class people who find it just too expensive when they need to avail themselves of it, and then for companies who want more efficient and innovative legal counsel. I guess in each of those areas, what has experience shown?
So the experience in England and Wales doesn't lift simply and easily into the US, because we start from a different place. So often people ask, what was the impact of the Legal Services Act and allowing non-lawyers to own law firms? Well, it's had some impact, and I'll come back to that, but it's narrow, because even prior to that, as I say, non-lawyers could run legal businesses covering 85% of our legal market. So the liberalisation was about how the narrow, restricted practices around courts and certain other areas were done. So you need a bit of sophistication in looking at the research to understand what is it it's impacting on. And I've posted in the comments a blog I did jointly with Zach Demiola when he was at IELTS, looking at some of that, and that's got some links to some of the research. But broadly speaking, what we can see is that across the piece, there are different sorts of businesses delivering than traditional law firms in ways that customers value. So we see it in non-profits, we see it in technology, we see it in small business services, all the way through to the use of technology, labour arbitrage, multidisciplinary teams for small businesses, all the way up to global businesses. There's not really a bit of our market that hasn't been touched by these sorts of changes. What I always think is quite entertaining about that is that huge numbers of those businesses are US businesses, and they're allowed to do things in England and Wales that they're not allowed to do in their home state, their home country. And that seems to me absurd. Rocket Lawyer and LegalZoom can deliver legal services in the UK. Axiom, Elevate, all of these sorts of businesses. They can have an ABS, they can deliver non-regulated legal services in the UK, and they're doing it and they're thriving and their customers love it. What I think is the second interesting part is how law firms respond. So, big law and what we call high street law, small firms serving local communities and individuals, have all had to respond, or most of them have had to respond to competitive pressures. So lots of our big law firms have their own alternative provider that delivers technology and paralegal delivered, process management delivered, alternative type services, because they're getting pressure from clients to standardize, make predictable costing, better quality, faster processing, all of those sorts of things. And we're seeing the emergence of multidisciplinary across the piece as well. So multidisciplinary services for relationship breakdown that bring together lawyers and all sorts of other people as well, counsellors or financial advisors or education advisors, all the things that go along. And that goes to thinking about this market in terms of customers, not lawyers. If you come at it from the view of customers, they don't have legal problems, they just have problems. Those are disputes, risk issues, life issues, whether they're individual, small business, big business, global business, they have life events. And if you only try and if you think every problem is if you're a hammer, you think every problem is a nail, and lawyers think every problem is a legal problem. And actually, if they work with others, they see them as multidisciplinary problems, and that leads them to practice with others as well. So we're seeing a real emergence of multidisciplinary practice across the UK market, and I think that is the shape of the global legal market over the next 25 years.
Well, that is fascinating. It shows when you re-regulate or perhaps deregulate in the UK case, you do see the emergence of these services and the consumption of them. So clearly there's a strong market for this kind of increased availability, affordability, efficiency, and so forth. Lucy and Deno, I know it's early days for Utah, and you certainly collected incredible data on activity and the consumption of services and on the very, very small number of problems with those in terms of claims from consumers. Have you run any analyses of sort of the relative cost of the services being offered versus sort of a traditional way of getting that kind of advice? Although Deno made the good point that sometimes the comparison is nothing because no transaction would have happened given the unaffordability. Have you been able to do any early analyses on that?
That is a great question, Chris. We definitely could. We have not yet. We do collect amount paid by consumers, but we have not run that kind of broad analysis yet. I think we're getting to the point where we possibly could do some preliminary looking at that, given how many services we've provided now. But yeah, that's a great idea.
But clearly, Chris, I mean, in a lot of these cases, it was zero. And a lot of these services are for free, right? So at least Lucy's right. We need to and we can. But anecdotally speaking, again, I think that's clear. I want to jump into our good friend Bill Henderson's question, because I think Bill is really, of course, he's right. I think that he's right to be skeptical that the change to 5.4 can impact A2J very much. If you think of A2J, really, I think, Bill, on just the lower end of the economic spectrum. I think you're not as right if you're thinking as it moves up the economic spectrum. That having been said, that's not really the push, right? It's just one tool. I think if we're going to make the kind of change in A2J that we need to make on kind of, at 150 or 200 or 250% of federal minimum poverty guidelines, it's not the 5.4J change, but it is core processes like ODR that are coming. And it's also just liberalizing the UPL and doing the shackles on the folks that can offer free advice or really low cost advice. You've heard me, go on and on. want to get, I used to call it the community first responder, but I've been told that rubs some people the wrong way because I'm usurping the first responder label. But those people, those trusted community advisors that are on the ground, the religious leaders, people like in the Upsolve case, educators, librarians, social workers that can offer these services for free, legal advice for free. So I think it's a multifaceted approach, and the different facets impact different parts of the economic A2J totem pole in different ways.
Yeah, and just jumping on that real quick, because it dovetails with Mark Lortson's question. I agree. I mean, I think, ABS reform is important because capital is going to help drive some of the greatest innovation, right? Particularly the innovation that involves software and non-lawyer, at scale. And that's another reason for thinking about entity regulation versus individual, role regulation. So all of those pieces are really important when thinking about, for states that are considering this, like thinking about what avenue do we want to choose. And it's not really an either or question. There's all of these things can be, applied in different ways. But with the sandbox, we explicitly wanted to have that option absolutely on the table, where there are highest innovation category, also highest risk, so they would have the most reporting data requirements. But we want to see entities that are not driven by lawyers, that are not having lawyers providing the services, that are really bringing innovation from completely outside of our world to bear, and capital from outside of our world to bear. And I really think those two, ultimately, hopefully, that's where we're going to see the biggest scale and the biggest impact.
Yeah, and I would just add to that, and on Bill's point, of course, re-regulation, liberalization, deregulation, whatever you want to do in that space only gets you so far. There's not a magic answer to improving access, but it's one part, and then we've got to make sure that we focus on all of those other parts as well. Simple forms, simple court processes, public bodies that make it easy for people to engage with them and disagree with them and challenge them. There's a whole range of different things that we have to do. And I think Upsolve are really smart at trying to fight all of those battles, and it needs people on the ground to do it rather than, me theorizing from 5,000 miles away. And Rohan's really masterful at that, I think, taking an issue and saying, what are all the bits of the solutions here?
Interesting stuff. I mean, so speaking of capital and innovation in states that are starting to allow this, I want to go back to a question that Greg Siskind asked earlier on, and sort of a variant of that. There are clearly organizations, law firms, ABSs who are applying to provide legal services in these states. I think, Lucy, you mentioned Arizona as a place where this is happening. And to what extent are the regulators, namely the state bars in states that aren't allowing this, which is the vast majority of states, reacting to that, and perhaps giving them problems in their home states or traditional non-innovating, non-re-regulating states? Are they running into any problems if the regulators are saying, wait, look what you're doing over here, clearly you must be doing that in this state as well? Is there a regulatory backlash of any kind?
So I can start. So it's tricky, right? I mean, it's a whole nother challenge that we have to tackle at some point, which is our multi-jurisdictional bars, right? I mean, obviously, Chris, you and I are in California. We don't let anybody come in here who's not sat the California bar. So it's a challenge. What we say to our entities in Utah is, look, we are authorizing you to do this to the extent of a law license in Utah, right? So whatever you can do as a licensed Utah lawyer, that's basically the extent of what you can, that's the max of what you can do as an authorized entity, or what your lawyers can do if they're working for an authorized entity in Utah. And I think Arizona would have to say the same thing. But so really the challenge is now, of course, there's more than just specific state practice within that, right? There's federal practice. There's a range of federal practice opportunities, I think, that that folks are definitely focusing on. We have a lot of immigration applicants in the sandbox. But what we have said is, look, we can only authorize you according to our authority as the Utah State Supreme Court, right? And you bear any risk to the extent you're going to push that. So if you want to bring a California lawyer in as practicing whatever, like you're going to risk the California bar coming against that lawyer, or potentially coming against your entity. And like, but that's really on you to figure out, and that's on you to determine, as a business strategy, like, how do you want to perceive that risk?
And I think Lucy's right, and I think that's all regulators can ever say, which I guess is why people like me exist, to help businesses go and push those envelopes. And this isn't new. It's not just across state boundaries; it's international boundaries as well. And there's a long history of this. So you can take a business like a law firm like Reed Smith. It's a global law firm. Well, when it's operating in England and Wales, it's an ABS with non-lawyer ownership. And we're not seeing state bars trying to close them down in the US because they're messing, with unethical practice just over the sea. There are ways of doing it. There's ways of doing it from one state to another. There's structures you can put in place, and it depends what you're trying to do. But there are ways to do everything, either with Arizona and Utah or from another state. There are ways to do this and to bypass regulatory restrictions. More and more businesses are looking at it. And because they're confident of their position, they don't even go and ask for permission.
Like those hundreds of Big Four lawyers who aren't just serving tea in the US, it sounds like.
Yeah, well, perhaps they are serving tea. Perhaps they are serving tea, and I'm just misjudging.
That's right. Well, a sort of a variant of the question, and this came up from Marcy in the chat. Obviously, there are far more states who are not looking at this, are opposed to it. Lucy, you posted four states who are now considering it. But there's been some backlash and some, shall we say, avid disinterest in pursuing this. And particularly in Florida. Lucy, were you involved in those efforts? And if so, do you have a sense as to why the proposal was so opposed there?
I was not, but I do have a sense. I mean, I think it's emotional and it's economic opposition. I think, it's real concern about competition. And I think it's also, it really is emotional kind of gut response of, this is how we've always done it. We kind of have this special role, which, we do, but that doesn't connect necessarily to these, as Crispin described, these huge walls that we've built around the profession. And ultimately, I think, Crispin makes the really good point. I think lawyers and state bars and Supreme Court leadership that are opposing this without really thinking are ultimately, it's very short-sighted. And I think ultimately it's going to be, history is going to look back and say that was the wrong decision. And I hope that folks are willing to at least kind of move past those emotional responses and try to really think and engage with the underlying really substantive, work that is being done in this space, really thinking about how can we move forward with these reforms and protect consumers and open up new avenues of employment for lawyers, like new roles, in new organizations, salaried employees working, for the public. Like, I think there's a lot of excitement and opportunity here that gets missed with these kind of emotional reactions.
Well said. We have time for one more question, and I will happily avail myself of Deno's constitutional law expertise. It came from Jordan Furlong. Looks like Deno might have another comment in any event, but Jordan asks, would or could the upsolve case also be applied to commercial speech? In other words, could the exception to UPL enforcement apply if the provider charged a fee? And Deno, would love your thoughts on that and perhaps on the earlier question.
Yeah, so I was involved in the Florida efforts and the extent of spoken to them several times. And the underlying group had recommended to the Board of Governors, obviously, that they make the change. I think the answer is simply plaintiffs' trial lawyers. The plaintiffs that you have the fox guarding the hen house in terms of the sub-regulator being made up entirely of lawyers or almost entirely of lawyers you have a powerful, kind of minority in plaintiffs personal injury bar. And they guide a lot of that discussion, and we've seen it here as well. So, all right, enough of that. I don't know. I mean, so Jordan's question about, Upsolve didn't involve commercial speech. And the fact that it was free was something that the district court played on because it's an easier question. So is it going to get challenged? Yes, of course. But I don't have a prediction for how that's going to work out if we're talking about non-free legal advice, but it is coming.
Great. And I will, again, avail myself of the press. One of the final questions here from Judy, what motivation is there for lawyers to support the new idea? So from our firm standpoint, we really support innovation in the provision of legal services and the ability to deliver much more value to clients, whether paid or pro bono. We have put our money where our mouth is. We set up a technology subsidiary, coincidentally in Utah, or not coincidentally, it's a great state for innovation. And it's called 650, and it provides both online paid subscription products for companies that want to take care of their employment or privacy legal needs in a much more efficient way. It also provides a number of pro bono products for people facing debt collection actions or mortgage issues or problems with their landlords. And we're very proud of both. A number of other law firms are doing this, and we recognize that the future is not a protected walled guild. The future is in providing much more efficient services. So I know that many other lawyers feel the same way, and we need to act accordingly. So that is all the time we have for this session. Thank you so much to our panelists, Lucy, Crispin, and Deno, for fantastic presentations and discussion. Thank you to all the attendees for being here and providing great questions. Please attend future forums. We'll post the recording of this one, and you'll get publicity for upcoming ones later this year. Thank you all again very much. Bye-bye.